This is the matter of the United States versus William Denoff in the Supreme Court of the United States on appeal from the 17th Circuit Court of Appeals on case number 070268. Petitioners, you may approach.
Thank you, Your Honor. Madam Chief Justice, and may it please the Court, my name is Kavika Valalos, and along with my co-counsel, Rachel Heflin, we represent the people of the United States of America, petitioners in this case. At this time, I request 3 minutes reserved for rebuttal. Thank you. Your Honors, there are two issues at stake in this case. The first has to do with the Second Amendment, and as part of that issue has to do with the applicability of the statute. I will be arguing that the Second Amendment to the United States Constitution is not violated by the Gun-Free School Zone Act of 1997. And that the conduct of Mr. Denoff certainly falls within the regulatory powers and intent of this act. My co-counsel will address the Commerce Clause analysis, showing how the Commerce Clause is not exceeded by the Gun-Free School Zone Act of 1997. This court has, only on one occasion in the last century, made a decision on the Second Amendment. Unanimous.
Counsel, before we get into the issue of the Second Amendment, don't we have to determine if the law even applies to Mr. Denoff?
Sure, Your Honor, yes. And the law certainly applies to Mr. Denoff. We can look at the text of the law itself and even the actions of Mr. Denoff in the case below to show that the law absolutely applies to his conduct.
Counsel, shouldn't Mr. Denoff be covered by an exception to prosecution where his home school was teaching his children gun safety as part of the curriculum?
Your Honor, no. And the reason there is because his homeschool program to teach that as part of the curriculum was not approved by the state. In other words, he did not receive permission or license to teach that aspect of the curriculum under the laws of Olympus.
Counselor, did Olympus require that non-required or elective courses, such as gun control in this case, be approved by them before they were taught in a homeschool?
Your Honor, the record is unclear, so I do not know the answer to that. However, it is clear that Mr. Denoff assumed that on some level the state absolutely regulates what is taught. In fact, in the record it shows that he told the police officers after he allowed them to enter his home that he did not receive permission, and to his knowledge the state did not know that he was teaching this program. He also states that he did submit for approval his curriculum, but not that aspect of his curriculum. Therefore, Olympus does require some submission of curricula.
But if he's the headmaster of his school, does he actually have to go and apply to the state and ask, what if he wanted to teach karate to his children?
Yes, Your Honor. Again, the record is not clear as to what the state specifically requires. But what we can rest confidently on is the fact that the state requires some submission of the curricula. And he points out that he did not receive approval for this program. And what this substantively means is that the state is not involved in that aspect of the school program, and therefore he ought not be able to claim that as a school he is legitimately able to teach this as protected under that exception which he applied.
Well, does that really make any difference to whether he had possession of guns or not on in a school zone?
Not, Your Honor, directly to the possession issue. Is the question more of is it a school zone?
Yes.
Yes, Your Honor. It is indeed a school zone. And we can look to the intent of Congress as given in the findings and even the definitions in the law itself. The law has two key definitions. One definition is a definition of a school. And the federal government Congress has defined a school to be an institution that teaches secondary and primary education as defined by state law. Mr. Denoff registered under the Olympus Homeschool Registration Act of 1987. Clearly, he is a school and operating a school registered to do so in the state of Olympus. So he falls within the idea of the schools. Now, the other definition in this act has to do with the school zone. And a school zone is the area of 1,000 square feet around a public, private, or parochial school. The United States government contends that a homeschool is indeed a subset of a private school. Indeed, it is not taught by employees of the government, but is indeed taught by an individual who is private, Mr. Denoff.
But a parochial school is also a private school, and Congress showed that when they wanted to differentiate, they could. So if they wanted to include homeschools in their definition, they could have blatantly stated it.
Perhaps so, Your Honor, but that is not in a record, and then the government would dispute that claim specifically because it is not defined what a parochial school is. We contend a parochial school is a church school, a church that runs a school as permitted by the state of Olympus. This is not what is in the case here. A church school would be separate from, as a religious institution, just a normal private school. In any event, a homeschool certainly is private. Mr. Danoff teaches his children and is authorized to do so under the school laws of Olympus.
Okay, Counselor, but why don't we cut to the chase here? What is the compelling governmental interest that allows Congress to enact the GISA, and how is it related to Mr. Danoff's rights here?
Yes, Your Honor. We would only look at a compelling interest test if this court upholds the idea that it is an individual fundamental right, and thus strict scrutiny would apply. The government does not contend it is not an individual right. In fact, we contend that it is irrelevant as to whether it is an individual fundamental right because strict scrutiny is upheld in the case at bar. There is a compelling interest as a first prong of the strict scrutiny test. Specifically, we look at the law on its face and as applied. So turning first to law on its face, Congress delineates in the findings, and we agree, that there is a compelling interest of the state to protect and preserve the integrity of education in this country, as well as to ensure that students are not in danger of and do not have the fear of guns present on their campus, which leads to violence, and as we've seen historically, is detrimental to an educational environment.
But, Counselor, in this case, isn't one of Mr. Danoff's arguments that he's homeschooling his children and part of his curriculum is gun safety?
Yes,
so aren't these children more safe because they are being educated in gun safety in their own school?
Your Honor, the argument may be true. However, when we look at Mr. Danoff, we see that they are actually less safe. There are 7, 9, and 12-year-old children in this home, and the homeschool room is adjacent to the room he teaches his children how to handle weaponry, right adjacent with no locks on the doors. In fact, the police officers found that there were hundreds of guns in this room, some loaded, completely unlocked, and with no locked windows or doors. These students, being 7 years old, cannot be entrusted with the maturity to not go into the room and not put themselves into some danger when Mr. Danoff is not there.
But did the state of Olympus require Mr. Danoff to do anything in his home in regard to his firearms?
No, Your Honor. However, the compelling interest argumentation here relies on the federal government's power to regulate, not on the state's power to regulate. Because the students of Mr. Danoff's home are in extreme danger, being only 7, 9, and 12 years old, to be in an area with unlocked and loaded weaponry, we see that there is a compelling interest even to protect them. So as applied, the compelling interest test is met.
But wouldn't that same logic apply in any circumstances, not just in a school zone?
Perhaps so, Your Honor. I don't understand.
If anyone in proximity to a gun is in danger, then your contention is in essence that the government has a compelling interest to limit guns, period.
Yes, Your Honor, there is a compelling interest. However, the Commerce Clause and Second Amendment must be upheld, which turns to the Miller argumentation in the case there, because that would limit the government's ability, even with the compelling interest. That is narrowly tailored. Essentially, Miller holds that the point of the Second Amendment is to preserve the efficacy and preservation of a militia. A law that completely bans weapons outright would be unconstitutional, and we do not contend that this law does so.
Even if people within the proximity of those weapons are in grave danger.
Well, yes, Your Honor, if complete banning at all times of weapons would be unconstitutional. The law at bar, however, does not do this. The law regulates simply those class of guns that have passed in or affect interstate commerce. Co-counsel will address the commerce powers question there.
So if Mr. Danoff's home had guns that did not move, you can answer, that did not move in interstate commerce, would his children be in any less danger? And if so, then how does the government have a compelling interest to regulate only those guns that have moved in interstate commerce?
Yes, Your Honor. The compelling interest argument would not trump this case if the Commerce Clause does not allow this to occur. If the Commerce Clause allows this to occur, as my co-counsel will argue, then the compelling interest argument would apply to show that strict scrutiny is achieved, which we argue here.
Thank you.
Thank you.
Madam Chief Justice, and may it please the Court, my name is Rachel Heflin, and today I'll be continuing the arguments for the people of the United States of America, petitioners in the case at bar. Your Honors, in 1995, this court struck down the first Gun-Free School Zone Act of 1990 on the grounds that, quote, by its own terms, it had no connection to interstate commerce.
So, counsel, what did Congress do to correct that, if anything?
In Section 2A of the 1997 version of the Gun-Free School Zones Act, Your Honor, we find that Congress specifically added a jurisdictional element to ensure the limitation of the application of the statute was to only a discrete set of firearms and not all firearms across the board. We find that the first Gun-Free School Zones Act applied to all weapons, regardless of any connection or lack thereof connection to interstate commerce, whereas the jurisdictional element in the second act expressly limits the application of Congress's regulation powers to only those weapons which have, quote, passed in or affect interstate commerce.
But the case law that we have before us modifies the fact that it has to affect interstate commerce. Doesn't it have to substantially affect interstate commerce also?
Actually, Your Honor, when we look at the case law set forth by the Supreme Court and the Circuit Court's interpretation of Lopez, we find that the jurisdictional element does not actually require Congress to meet the substantial effects test. United States v. Morrison and United States v. Wilson refer back to this court's holding in United States v. Scarborough in 1977, which set forth the importance of the jurisdictional element.
But Lopez was decided in 1995. Don't you think that supersedes the 1977 decision?
Well, Your Honor, in United States v. Morrison and United States v. Wilson, both courts observed that Lopez did not overturn the jurisdictional standard of a minimal nexus that must be met.
Is Wilson a Supreme Court case?
No, it is not, Your Honor. However, our decision in United States v. Morrison was, and upheld the validity of a jurisdictional element when establishing whether or not Congress had the power under Article I, Section 8. Specifically in United States v. Scarborough, we find that in order for a jurisdictional element to be valid, it must establish a, quote, minimal nexus between the object being regulated and interstate commerce. In United States v. Wilson and United States v. Lewis, in fact, in all of the circuit court decisions post-Lopez, the circuit courts applied Lopez and previous Supreme Court precedent and language regarding the jurisdictional element to mean that Congress could regulate any weapon that had passed through interstate commerce, so as long as its regulation was in fact proven and tied to interstate commerce.
Counselor, doesn't the record before us indicate that Mr. Denolf's gunsmith business was really nothing more than servicing and cleaning weapons for his friends and neighbors? Why should we consider that economic activity at all?
Specifically, Your Honor, because the facts of the case reveal that there was interstate commerce occurring. We know that 7 of his customers came from out of state. We also know that 20% of the component parts, including oil, lubricant, and solvent, were also taken from out of state or international providers.
I understand the figure was something like 3 or 4 out of 304 customers in a given year. Isn't that really de minimis in terms of economic activity?
Well, Your Honor, we're not actually measuring. Petitioner would respectfully submit that we don't have to measure the amount of economic activity in that, in using that scope, because the application of the statute is not to all of the weapons in Denolf's possession, but rather only to those weapons which have previously passed over interstate lines. We can actually go back to the civil rights cases, Heart of Atlanta Motel versus United States and Daniel versus Paul, to see the importance of a jurisdictional element when examining the constitutionality of congressional statutes under the Commerce Clause.
I guess I'm a little baffled by that then. So your contention is that the government has a compelling interest to regulate these weapons because of the danger that exists to the Denolf children, but at the same time the government can't regulate guns that haven't moved in interstate commerce, which pose the same risk and same danger to the family. How does the government have a compelling interest at all?
Well, as co-counsel already argued, the government has a compelling interest to protect children in school zones. However, having the compelling interest does not mean that Congress may simply regulate something, but rather they must achieve their power from an actual grant of power given in the Constitution. Thus, we would respectfully submit that because of Article I, Section 8, Commerce has been granted that power necessary in order to meet the requirements of the compelling interest test. Specifically in United States v. Morrison, we see that this court struck down the Violence Against Women Act, holding that what was being regulated in the act was nothing more than criminal activity unconnected to interstate commerce. However, the court went back to the language used in United States v. Lopez and observed that had a jurisdictional element been present, the finding of the constitutionality of the statute would have been very different. Similarly, the statute in United States v. Jones regulating arson, criminal activity, was upheld because it restricted the application of the statute only only to those buildings which had been used in interstate commerce. Similarly, we find that in the second Gun-Free School Zones Act, only those weapons which have an explicit connection to interstate commerce may actually be regulated. Regulation of the rest of the weapons must fall to the states under their police power.
Now, in Jones versus the United States, we upheld we found that the statute did not apply to Mr. Jones in that case. So we could find that it's constitutional, the Gun-Free School Zone Act, but that it doesn't apply to Mr. Denolf. And I'm still not seeing this minimal nexus, whether it's a substantially affects or a minimal nexus test. I'm not seeing how this law applies to Mr. Denolf's activities.
Yes, Your Honor. Well, the facts in the record given to us are rather vague. We don't know how many weapons in his possession at the time of indictment did have an explicit connection to interstate commerce. But we know that during the period of time that he possessed weapons in his home and the Gun-Free School Zone Act was enacted, we do know that there were weapons in his possession that had passed through interstate commerce. We know that, as the record says, he was involved in interstate commerce in manufacturing and transferring these weapons across state borders. In United States, in Heart of Atlanta Motel versus United States, and in Daniel versus Paul, simply the movement of ingredients in soda and flour and bread, this court found to be ample evidence for the regulation of something that was causing a social ill, namely racial discrimination. Because the tools used by these restaurants and places of public accommodation were used to further a social ill, Congress believed and the court found that they did in fact have power under the Commerce Clause to regulate it. Such are the circumstances in the case at bar. We find that gun possession...
If I may interrupt, counsel, in the case at bar, we have a situation where there's a gentleman who has a homeschool for his children. It's a homeschool. It's within the privacy of his home, and all of these guns and weapons are kept inside the privacy of his home. Whereas in Heart of Atlanta, you have a situation where there is a hotel receiving guests that are in and out of state. How would you compare the two? How would you distinguish the two?
Well, specifically, Your Honor, this court has found that guns in schools are a social ill, as seen in the findings. We do not rest upon the findings in order to determine the constitutionality of the statute, but we do see in the findings, in fact, a compelling interest to keep guns out of school zones.
But of course, violence against women was a social ill, too, and that wasn't enough to save it in Morrison, was it?
No, Your Honor, that's right. Because the court found that there was no jurisdictional element present in the Act to ensure that those regulated because of their violence against women had previously had an explicit connection to interstate commerce. When we examine all of the circuit court decisions decided post-Lopez, we find that they have all unanimously upheld statutes regulating gun possession on the grounds that a jurisdictional element was present in the statute themselves. In United States versus Wilson, we find that felons are forbidden to possess weapons in interstate commerce or weapons that have passed over interstate lines.
Well, there's no evidence that Mr. Denolf is any sort of felon. You may disagree with what he's doing personally, but there's no evidence that he poses any danger.
No, Your Honor, but that goes back to the compelling interest, and that regulating felons is a compelling interest in infringing on the Second Amendment. And similarly here, we find that the guns in schools, in the school zones, is another compelling interest. However, in United States versus Rybar, we also see the same jurisdictional element present, in that machine gun possession in or after these machine guns have passed through interstate commerce was similarly banned. United States versus Wilson, in referring to the Supreme Court's decision in Lopez and United States versus Scarborough with the minimal nexus language, found that in its previous decision in 1996 in United States versus Lewis, which was also post-Lopez, the United States versus Lewis upheld a statute that allowed the regulation of firearms that, quote, had passed interstate lines. Thank you.
Thank you.
You may begin, counsel.
Madam Chief Justice, and may it please the Court, my name is Peter Kamakuva-Ole, and along with co-counsel Holly Vradenberg, we represent the respondent in this case, William Denolf. I'll be presenting arguments on the first issue, that issue of the Commerce Clause, and co-counsel will deal with the statutory question and the application of the Second Amendment to today's case. Your Honors, unfortunately for petitioner, what this current statute, 18 U.S.C. 922Q, attempts to do is to do, as this Court described in Morrison, to appropriate state police power under the guise of regulating interstate commerce. This statute falls far beyond Congress's authority under the Interstate Commerce Clause for three reasons. First, This statute does not satisfy this court's requirement that statutes dealing with interstate commerce must first regulate economic activity, which this court has consistently upheld as either the production or the transaction of a good. Second, Denolf himself and the guns in question don't even meet the statute's standing requirement that the guns must either move in or otherwise affect interstate commerce.
Well, isn't it a fact that some of the weapons did move in interstate commerce, and some of the materials used in his work on these weapons, either in building them or cleaning them or otherwise servicing them for his customers, did move in interstate commerce?
Your Honor, while it is true that Denolf has sold 4 guns to out-of-state customers, the fact of the matter is that he no longer possesses guns that he's already sold. He can't be charged by the government for possessing them. It's also true from the record that he's repaired in the past at some point 3 guns that came from out-of-state customers. But again, it's the burden on the federal government to achieve standing under the statute to demonstrate that Denolf has those guns in possession at the time of the search and the trial, and the federal government has failed to do that.
Counsel, doesn't he always have in his possession the materials that he needs to service these weapons? And isn't it a fact that some of the materials, the solvents, etc., did move in interstate commerce, and as a responsible gun cleaner and builder, he would have those on hand at all times?
Your Honor, there is no indication in the record that the solvents themselves have moved in interstate commerce. All that the record says is that about 20% of the component parts of those things, but again, that's not even the component parts of the guns. The record is very clear that all the guns are made interstate, all the component parts for the guns come from interstate sources, excuse me. It's only component parts of some of the solvents that are used. This court described a similar chain of events in Lopez as piling inference upon inference. The fact of the matter is that there is no clear connection between the mere possession of firearms, in this case, in Denolf's case or generally, and interstate commerce.
But what about in Wickard, where we held that an activity can be entirely interstate and entirely local, but it can still affect interstate commerce?
Your Honor, that brings me to my first point, which is that even in Wickard, there was an economic activity present. The regulation at issue prevented, again, Wickard from producing grain. This court has upheld numerous statutes that place regulations on the economic production of something for sale or the transactions of something. But again, the current statute before this court does not regulate the manufacture of guns. It's a mere anomaly that Denolf is manufacturing guns in the instant case.
Counsel, didn't the expert analysis in the record indicate that there was some $10,000 in sales and service charges that were procured by Mr. Denolf running this business in the last year analyzed? Isn't that substantial economic activity?
Your Honor, it is true that Denolf himself is generating economic activity. But the fact of the matter is that Denolf would be equally culpable under the statute without his gun business. The statute itself regulates the possession of firearms. Denolf would be equally in violation of the Act without the economic impact of his gun business.
But shouldn't we be concerned about the activities of 50 similarly situated individuals like Mr. Denolf in 50 states in the Union? Isn't that a concern properly addressed by Congress in the statute?
Well, first of all, Your Honor, there is no evidence in the record to show that it's likely that there are people similarly situated, which was a requirement in this court's aggregation under Lopez, under Wickard. It had to be likely. But furthermore, if this court were to deem that substantial, it would call for an entirely separate statute. Congress could then look at that and determine that 50 people creating a $300 impact on interstate commerce is effective, and ban the creation of guns, the manufacture of guns in school zones. But that is not what Congress attempted to do in the instant statute. And as this court stated in Lopez, mere possession of a gun is not economic activity, and that fact has not changed.
Wasn't that what Wickard was charged with, mere possession of the additional wheat over the quota? What Raich was charged with, mere possession of marijuana? The idea was that in the aggregate, these activities do have a substantial effect on the commercial markets. Wouldn't that be the case in this as well?
Your Honor, Wickard was charged with the production of wheat over quota. Again, as I've already stated, production of wheat, a commodity for wheat, is an economic activity, whether or not it enters the interstate market or not. And the court in Wickard reasoned that because he was growing wheat over quota, he wouldn't be buying wheat from additional sources. Again, it's a clear economic impact.
Well, isn't I'm sorry.
I say, well,
You can go.
But in Raish, that was also a possession case, and in fact, in that case, the possession was legal under state law. So in this case, we don't have any state law regulating the possession. Why is it different?
That's correct, Your Honor. Now, it's important to realize that the statute at issue in Gonzalez versus Reich regulated 4 classes of activity, not just mere possession. Possession was one. There was also the manufacture. There was also the distribution and the dispersal. What the differences between distribution and dispersal is, I'm not quite sure. But the point of the matter is that even when discussing mere possession, this court in Reich stated that the possession that was at issue there is far different than the mere possession of guns that it examined in Lopez, because possession of an illegal substance, such as marijuana...
But it wasn't illegal in California to possess marijuana.
Okay. Let me rephrase. The possession of a controlled substance, which is what the act was at issue with. This court stated that the possession of such substances, even if for legal purposes, like even if the purpose of producing it was for medicinal purposes solely, this court stated in Gonzalez that it was extraordinarily likely that such legally grown marijuana would enter an underground black market. Now again, the emphasis here is not so much the presence of the black market, but the likelihood that mere possession will become economic activity.
Well, isn't it likely that mere possession of 300 weapons is going to result in some economic activity?
Your Honor, again, the statute doesn't... Yes, obviously when you look at the particular facts of this case, that's the case. But the statute doesn't regulate on the basis of that. It says that essentially we would have to argue that the possession of any gun is equally likely to become economic activity, because whether you have 1 gun, 3 guns, or 300 guns, the statute applies to you equally.
But only if you're within 1,000 feet of the school zone. So it seems to me to be very narrowly tailored.
And only if the gun moved in interstate commerce, further narrowing.
That's correct, Your Honor. Now, I would defer the school zone question to my co-counsel, who will be dealing with that particularly. But to move to the moved in or otherwise effects requirement, which opposing counsel has attempted to cite, the important fact of the matter is that the jurisdictional element present here is essentially non-existent, because what Congress found is in its findings is that virtually every gun at some point in the process moves in interstate commerce. That virtually every gun at some point in the process, or every instance of gun violence at some point, affects interstate commerce. The effect of the jurisdictional element is simply to package in quote-unquote constitutional terms the exact same statute for all practical purposes that this court struck down in Lopez.
But isn't that perfectly allowable, as the commerce power is plenary?
It is, Your Honor, but again, as this court stated in Schechter Poultry Corporation versus United States in 1922, as cited in our record in NLRB versus Jones, a statute, the government cannot employ the Commerce Clause to effectively obliterate the distinction between what is national and what is local. This court stated in Lopez that regulation of guns, regulation of crime, is a purely local activity. And what this statute does is it attempts to use constitutionally permissible language to simply usurp a state power.
How can we be obliterating state power when Olympus chooses to do nothing in this arena?
Your Honor, in Screws versus United States, decided in 1945, as cited in our record in Lopez, this court made it very clear that any time that the federal government attempts to define a crime that the state has already defined, there is an impermissible inference and interference into the state's ability, plenary authority, state police power to regulate crime.
But I didn't think that the state of Olympus had defined any crimes with respect to the type of weapons and the type of activity that your client was engaged in.
That's correct, Your Honor. But as this court stated as far back in 1821 in the case of Cohens versus Virginia, as cited by Justice Thomas dissenting in Gonzalez, the ability to punish felonies and simple crime has always been the realm of the state and not the federal government. For these reasons, we urge this court to side with the opinion of the 17th Circuit and affirm in favor of respondent. Thank you, Your Honor.
Thank you. You may begin.
Madam Chief Justice, may it please the Court. My name is Holly Bradenberg, and I will be continuing the arguments for the respondent, William Denolf, in the case at bar. I will be addressing two issues. First, whether the Gun-Free School Zone Act of 1997 applies to Mr. Denolf in his particular circumstances, and second, whether the application of the statute to Mr. Denolf would result in an infringement of his Second Amendment rights. I will start with the first issue, the statute issue, for the logical reason that if today respondent is able to convince this panel that this statute does not fall, or that William Denolf does not fall within the purview of this statute, then the case is closed, and we don't even need to move on to the constitutional evaluation of this statute. There are three primary reasons why the statute does not apply to William Denolf. First, we see from the definitions of the statute and from the findings of Congress that Congress never intended this statute to apply to homeschool families that are schooling their children within private residences. This is peculiarly evident by finding number 5, or finding number E, which states that the very reason for enacting this statute was that Congress was afraid that parents would be afraid to send their children to school for fear of gun-related violence. That was the whole reason for enacting the statute, was this reticence to send children to school would result in a damage to local school zones and municipalities and governments and economies, and there was this whole domino effect that would occur because parents would choose to keep their children home rather than to send them to dangerous schools.
So your client chose to keep his children at home and place them in an environment where there were guns a few feet from their school desks. So why does the government not have an interest in protecting your client's children?
Protection from violence was also one of the findings.
Yes, Your Honor, protection from violence in school zones. So in order for this particular statute to apply to William Denolf, it must be proven that the homeschool is a school zone under congressional intent.
Well, isn't it? It's a private school.
No, Your Honor, we find that the state of Olympus does not sweep homeschools into the private school category. This is evidenced by the fact that the record states Denolf registered under the Homeschool Act of 1982 in the state of Olympus. Now, obviously, unless the state of Olympus has no private schools, which I find doubtful, there must be some separate category for private schools to register and to conduct education under Olympus state law.
Maybe Olympus has drawn a distinction, but we're looking at the federal law. Why wouldn't, under the Gun-Free School Zone Act, homeschools count as private schools?
Exactly, Your Honor. And for those reasons, I would refer your attention again to finding E, which states that they were concerned for parents when they enacted the statute, and for parents' ease of mind when they're sending their children away in times when parents are not directly supervising their children. Obviously, that is not what is that case when William Denolf is homeschooling his children. He's homeschooling a 12-year-old, a 9-year-old, a 7-year-old. They're his biological children. They're within the confines of his own private residence.
Once again, Counselor, given the fact that the children were as young as they are in this case, shouldn't we be concerned, as the Chief Justice's earlier question addressed, the fact that Mr. Denolf had loaded firearms, loaded rifles, in an unlocked room in close proximity to where the children were being taught? Isn't that a legitimate concern for the state?
Your Honor, it is a legitimate concern to be concerned for the safety of children. Now, Denolf claims that he, handles these guns responsibly and teaches his children to handle these guns responsibly. But the bottom line here is that we cannot charge Denolf, even if Denolf's children are in danger in this circumstance, which we would contend they're not. But we cannot charge him under the 1997 Gun-Free School Zone Act. He does not fall within the purviews. Another reason why we...
Not so much you say that they're not in danger, as Madam Chief Justice has just said that, they're in a room where the weapons are in a room that are not, the room is not safe in terms of the safety precautions. So why would they not be in danger? The weapons are loaded. The windows are unlocked. They have easy, even though they have not been inside the room, it's still within proximity to the classroom.
Your Honor, it is impossible for me to stand here and to prove empirically that Denolf's children would never be in danger from his guns. But we're talking about a separate issue again. We're talking about protecting children from their parents and from gun-related violence in that way. The statute does not apply to homes. If Denolf did not homeschool his children and ran that gun shop, we could not charge him under the statute. That question would not even be in front of this court today.
But then the guns wouldn't be in a school zone, so there wouldn't be an issue. So I come back to, why is this any different from another type of private school where the headmaster lives on the premises and maintains a gun in the headmaster's house, for example?
Exactly, Your Honor. If we look at the wording of the statute, we find that it says it shall be unlawful for an individual knowingly to possess a gun that is moved in or otherwise affects interstate or foreign commerce in an area where the individual knows or has reasonable cause to believe is a school zone. Now, so in other words, we would not only have to find today that Denolf's homeschool is a school zone, which would result in a very dangerous precedent, but we would also have to find that we had reasonable cause to charge Denolf with knowing that he was a public, private, or parochial school zone.
Didn't he apply under all these acts? He jumped through all these administrative hoops and to be able to be a homeschool, so he can't be charged with ignorance. Ignorance of the law is no defense.
Yes, Your Honor. He knew he was a homeschool, but we cannot say that he knew that his homeschool was a public, private, or parochial school under federal law. Now, this is evidenced by the fact that the initial court under Judge Carolyn Bresson found that Denolf's homeschool was not a public, private, or parochial school and therefore did not fall within the purview of the statute. 17th Circuit looked at the case and decided, oh, well, yes, maybe he does. Maybe it does apply. Now the question is before this court today, and there's disagreement even between petitioner, respondent, and this panel. Is he or is he not a school zone? The question is, can we reasonably charge Denolf with having known that he was a school zone, even if this court finds today the homeschoolers constitute a private school under federal law? Furthermore, this would create a very, very dangerous precedent were this court to make that decision today, because there are numerous rules and regulations that apply to public and private schools that would be dangerous to impose on private residents and homeschool families. Opening up the door to that would introduce a plethora of problems. There are vaccination requirements. There are even dietary requirements about what kind of foods can be put in snack machines. There are zoning laws. There are all sorts of laws that apply to schools that we cannot infer what should apply to homeschool families, or if they did, would result in a significant infringement on individual freedom. Moving on to the issue of the Second Amendment, Your Honors, if this court finds today that Denolf does fall within the purview of the statute, which we contend he does not, but if he does, it would in that case constitute a violation of his Second Amendment rights.
Counsel, didn't our decision in Miller in 1939 embrace an analysis of the type of weapon that the defendant had in his possession and whether or not that would be the type of weapon that would ordinarily be used in the state militia?
Yes, Your Honor. The court in Miller found that a sawed-off shotgun was not afforded the same kind of protection as your average firearm would be because it posed a significant threat to the safety of others.
And given that analysis, Counselor, doesn't that support an analysis that also shows that we have already embraced the state militia or collective-based rights argument and rejected the individual rights argument that you're proposing today?
No, Your Honor, it would not. This court stated in the case United States v. Prince, which was cited in the Fifth Circuit decision of Emerson, and this Prince was decided in 1997, it stated that Miller had not decided the issue of individual versus collective rights. The court in Miller never stated whether the Second Amendment was a right guaranteed to the states or the individual. They merely stated that a sawed-off shotgun possessed by Miller was not.
If it's an individual right, what's the point of the analysis about whether the militia would use that type of weapon?
Because, Your Honor, another view of the Second Amendment that has been posited by circuit courts, which wasn't necessarily adopted in Miller, Miller was a little ambiguous, but would be that it is an individual right in relation to a militia. There are several different interpretations of the Second Amendment. Now, another way to look at the case of Miller, and this is one that was adopted by the Ninth Circuit in the case Silveria versus Locklear, Miller actually gave, the court actually gave Miller standing to posit a Second Amendment challenge as an individual. And we find that Silveria versus Locklear and then a later Ninth Circuit decision of, I'm sorry, I can't remember, Nordyke v. King, there you go, Nordyke v. King, they both found that individuals could not bring suit under the Second Amendment and would not even grant them hearing because if it's a state's right, an individual doesn't have standing. The Supreme Court has obviously rejected that analysis in even granting Miller standing. Because the statute does not apply to Mr. Denolf for the reasons stated, and because the Second Amendment would be violated if this court were to find the statute does apply, we respectfully urge this court to rule in favor of the respondent today.
Thank you.
May it please the court. Opposing counsel rests their applicability argument on finding E to point out that Congress never intended for homeschools to be regulated. But finding E, as she quoted it, is not the full quote or the point of finding E. Finding E points out that some people will be afraid to travel throughout this country, thus affecting interstate commerce, if guns are present in school zones and guns are there because of gun violence and the fear of guns. Finding E concludes after the comma that some parents are also afraid to send their children to schools. The point here is that Congress has much broader interpretation and purpose with this law than simply dealing with schools in which people send their children to. The very last...
Be expected to be applied. I'm just thinking Virginia Tech, Columbine all occurred within the confines of a traditional school, but I can't think of one homeschool violent incident in the past 100 years. There's never been any sort of activity, so how can we have this apply to him?
Your Honor, outside of this record, there have been violent actions in homeschools, but again, outside of the record, it certainly applies to him because the law would limit his ability to, without permission, without approval, under the many exceptions, to possess these weapons because of the compelling interest. However, here it is a very narrowly tailored law because there are 11 exceptions that would have allowed him at any point to possess a weapon. Thus, it would certainly fulfill the strict scrutiny standard. It's important to know also, under Commerce Clause analysis, that opposing counsel rests his argumentation on the idea that Congress cannot expand their powers to just include anything that is likely to affect interstate commerce. However, he misses the point of the jurisdictional element. The jurisdictional element proves and guarantees that it is not likely to affect interstate commerce, but it is indeed involved in interstate commerce. And this court has held this to be true in U.S. versus Morrison, U.S. versus Jones, and the several lower circuit cases that did come after Lopez.
Why shouldn't we leave the decision to prosecute a small bore defendant like Mr. Danoff to the wisdom of the state legislature? Why should we disrupt the principles of federalism and allow Congress to intervene in such a situation?
Yes, Your Honor, it would not indeed disrupt the principles of federalism. As this court has held in U.S. versus Jones, when the Commerce Clause is appropriately applied, it is not a violation of the state's police powers to co-regulate. The idea of dual sovereignty is inherent and common in this court's jurisprudence. In fact, the very law before us, the very last section says that nothing in this act prohibits the state from passing similar legislation. There is no expansive powers here. The jurisdictional element guarantees and maintains that the guns in question have passed through interstate commerce. I urge this court to accept this argumentation to rule in favor of the United States.
Thank you, Counselor. Wow, what a job.
Well, we've deliberated on this matter, and I can tell you it was a very, very difficult decision because you were all fantastic. But we do have to make a decision, and so we are ruling in favor of the petitioners by a hair.